Okay, so we're live on Facebook as well. I see someone has raised their hand already. Hans, if you have a question for now, could you put it in the Q&A function on Zoom? Or if you have a general comment, you can put it in the chat function. And then later on, towards the end, we're going to do live Q&A, and then feel free to raise your hand again. But for now, you can ask it in the Q&A. It's just on the bottom of the screen. Kathleen, yeah, so the Zoom webinar can only be joined by those who registered before, but I can send you the Facebook link. So if you want to share with anyone that hasn't registered, you can send them this Facebook link, and then they will be able to watch it live. Oh, I've sent it to panelists only. There you go, you should have it now. So for those who are already here, feel free to introduce yourself on the chat, tell us where you're joining from. If you have any specific questions that you want our speakers to answer, you can join from you can ask in the Q&A function. And just between when the speakers are mentioning what they do and informing you, I will be posting some other links that they might mention on the chat as well, so you can follow, and they might as well. Thank you, Kathleen. And we've got Alexandra here as well, who's just helping me with any admin. If you ask any questions and she knows the answer, she might answer you straight away. Otherwise, we can wait for our experts to answer.
Good spread of places.
Yeah.
Let's go, Oxford.
Yeah, thank you for your point, Bridget. This webinar, where possible, will cover UK rights, but sometimes will be specific mainly to England. But again, the speakers will do their best to at least inform you where that situation is different and where you can find information depending on where you live. But some of the things will apply everywhere, and we'll try to make that distinction. I'm just sharing the link to Facebook Live again. If you are here and you think that this might be useful for a friend or family member, feel free to share that link with them, and then they will be able to watch live. But it's 5 past, and I know that people will keep joining, but we're going to get started for now. And you'll hear very little from me. Mainly you'll be hearing from the speakers, but I just want to say a few things. So basically, you've already heard from me, but those that have since joined, please ask your questions in the Q&A function of Zoom, so that the speakers know where to look for questions. If you have general comments or you're just telling your story a little bit, use the chat function. We do like knowing about those. but if it's not a specific question, then put it in the chat. And well, my name is Lara Perisotto. I am the co-manager of the Young Europeans Network, which is the youth wing of the 3 million. However, our work, our webinars apply to people from different ages and different backgrounds. And mainly we want to be providing information to EU citizens and migrants and British citizens in the UK. We've got this series called Life in the UK, and the reason for this is that we do a lot of campaigning on making access to British citizenship more affordable and more accessible. And I'm sure many of you on this call will have probably looked at or even taken the Life in the UK test. And I have done that back in September. And the questions that are on that are really not applicable to everyday life in the UK. So that's why we were playing on that name and providing these sessions on different topics that are actually important for us as residents, and that we should be aware. And it's important that we know our rights so that we know how to exercise them. So we've got a really brilliant set of speakers here who've got expertise in different areas, and will be telling us a little bit more about our rights and how we can campaign to improve our rights and to make sure that those are exercised. So let me, and then later on, we're also going to be joined by a volunteer who's going to tell us a little bit about their story in the UK with housing and struggles. I think all of us have at some point struggled with housing in the UK. But I'll start with our first speaker, Jackie Peacock. She's the Chief Executive Officer at Advice for Renters, and she will tell us a bit more about housing rights in the private sector. So if you are renting or in the process of trying to rent in the UK and you want to know more about your rights, Jackie is the person who will tell us everything about that. And she will be doing a little presentation. And as I said, we've got comments about it, chat, if you've got questions, Q&A. Over to you, Jackie.
Okay, thanks very much. Yes, I've actually, just for the record, recently stood down as the Chief Executive. So okay. I'm now able to focus on our policy work, which is much more exciting in many ways. Yeah, so I'm just going to share some slides. I should say that they are quite long. It isn't easy to cover all of our housing rights in terms of, you know, they are naturally quite extensive. So I'm going to go quickly through them. And as has been said, if you've got any queries, do put them in the chat or ask in the Q&A session at the end. So I'll just set up the slides now. Give me one moment. Sorry, I'm just having a problem finding the right thing. I'm not very good at this.
I think if you click the first button from beginning there.
That will probably do it, won't it? Yeah, just, yeah. Well, thank you, sorry. I was thinking it wasn't even ready for the slideshow. Fine, so just very quickly, I'll say a few words about Advice for Renters. You're very welcome to contact us at any time if you have problems. We have a range of services that we can offer, but our key one is our specialist housing advice team. So we can defend tenants if their landlord's taking possession, or we can help you with claims for disrepair, or we can give you general advice and help you perhaps to negotiate with your landlord if you have problems. But we also have a section called A4R Money, which includes helping people with debt or budgeting problems, financial inclusion, welfare benefits advice. We have a branch of Hillingdon Credit Union called Brent Mutual, which is available to any renters in our part of London, where we're based, Northwest London. And we also provide energy advice, which of course lots of people are going to need very soon, because I'm sure you know electricity, gas bills are going up very substantially from April. And we also encourage active involvement in our group. We are a membership organisation, and we have various groups, like ones that tenants that get together to tell their stories, and then they get translated into illustrative publications. We have a seniors renters group, and we also have a mentoring and befriending service. And last but not least, we do also do a lot of campaigning, and particularly at the present time, where the government is actually committed to increasing tenants' rights by getting rid of the notorious Section 21, which removes renters' security of tenure. Again, as we said earlier, some of us will cover the whole of the UK, but in my slides, I will be just talking about assured short hold tenancies, which is the main form of tenure. There are other sorts of renting which falls outside that, most of which probably won't apply to you, but if your home is part of your job, the most likely would be if you've got you're renting a room from a landlord who lives in the same house. So what I'm going to explain today doesn't include those people, and others that are people who've been generally renting for a long time, or in some form of temporary accommodation, or maybe renting as a company. If you say you work for a firm abroad and they sent you to London to work for a year, then the company might rent the property. And crucially, these slides only cover tenancies in England, and that's because the law does, with devolved countries, the law does change quite a lot in common with tenancies in Wales, but there are some differences. There are even bigger differences in Scotland and in Northern Ireland. So bear in mind, what I'm talking about today is short hold tenancies in England. The slides are in 3 parts, looking what you need to know before you actually take a tenancy and move in, your rights when you are in the tenancy, and what you do when the tenancy ends. So starting with what you need to know when you're looking for somewhere to rent. First thing to note is that all letting agents, if you're using them, they must belong to a redress scheme. And the 2 schemes are the Property Ombudsman and the Property Redress Scheme. And the purpose of that is if something goes wrong, you're not treated properly, or you say you're going to rent somewhere and suddenly it's not available, or it isn't what you expected, then you have got somewhere to complain to, and they will investigate your complaint. It's also unlawful for letting agencies to charge fees to tenants, and all the properties that are advertised to let should include the energy rating, which, as you probably know, it's the same for white goods and a lot of other things. If it's A, B or C, it's probably quite energy efficient, and it gets less so as you go down the alphabet. And these days it is actually unlawful for any landlord to let a home that is energy rated below E. It's also unlawful to let a home which is unfit for human habitation, which I'll say a bit more about later on. And so you've found a tenancy, you've said you'd like to have that tenancy, and before you move in, the landlord must provide certain information. They should give you at the start of the tenancy the government's How to Rent guide, and it must be the most up-to-date version, and they should also give you a paper copy unless you say that you'd actually rather have an electronic version. They also have to give you a gas safety certificate to cover all the gas appliances in the property, and that again must be up to date. Landlords are obliged to inspect all gas appliances by a qualified gas engineer at least every year. and they should also give you the energy performance certificate. You already should know the rating before you take the property, but the energy performance certificate not only confirms the rating, but it also, if you read the small print, it'll show you what actions could be taken to improve the energy efficiency. So if you think that it might be worth talking to your landlord about taking steps to improve energy efficiency, particularly these days where there are often grants available because of the climate change, there's a lot of effort going into persuading owners, including landlords, to upgrade properties. Sorry, I think I missed the last one on that list. Landlords, you probably know, are legally obliged to carry out what's called a right to rent check, which really means checking whether tenants do have a right to reside in the UK. So immigration, I'm sure you know, is a specialist subject, so I'm not going to answer any questions specifically about that. But if you have any questions, there's a lot of useful guidance online, including a guide from the Home Office. I did try and include a link to it, which wasn't working, so I've just spelt it out there, but happy to share the slides so you'll have that to check if you need to. But I dare say most of you have got the EU settled status by now. So also before the tenancy starts, although not legally requirements, a landlord who's acting properly should give you a written tenancy agreement. Even better if they give you a chance to read it. I know there's a lot of pressure to take a tenancy, and then the landlord quite often will just hand you the tenancy agreement and expect you to sign it straight away. So I would suggest that you do ask to be given a little time to read it, and if you're in any doubt, take advice about it as well. Also important to note is that traditionally tenancies have been for a fixed term, either 6, 12 months, occasionally longer, but they don't have to be. And there are some advantages in having what's called a periodic tenancy, which just runs from one rental period to the next, if you're not sure whether you're really going to want to stay for the length of a fixed term. They also should give you a record of electrical safety checks. Landlords do have a duty to inspect all the electrical installations at least once every 5 years. And they should also give you details of smoke alarms. Again, that's a legal requirement to provide those. And it's also good practice if you've got gas appliances to provide carbon monoxide alarms as well. Even better if they actually show you how you can test these regularly for yourselves. So you've moved in. What happens during the tenancy? Well, the first thing is you probably paid a tenancy deposit. Landlords can't charge you more than 5 weeks, equivalent to 5 weeks rent as a deposit. And when you have paid it, within 30 days, they have to register your deposit with a government approved scheme. And the purpose of that is if there's anything goes wrong at the end of the tenancy, then the scheme which is protecting your deposit will arbitrate and decide whether the landlord has a right to withhold any of your deposit or whether it should be returned to you. And so I've listed there the names of the different deposit schemes, and the landlord also has to explain the terms of the scheme as well and what you do if there is a dispute. Less well known is the right to challenge the rent. It sometimes happens, particularly if people are just moving to the UK and they maybe have to find somewhere before they actually arrive and move in, and they may find after they've moved in a few weeks that they're paying more rent than other comparable rents in the area. So you do have a right to challenge the rent within the first 6 months, which means you could apply to an organisation called the Property Tribunal, which is a legal body, and ask them to fix a lower rent. It's always, we have to bear in mind, of course, that if you have a short hold tenancy, you don't have a lot of security of tenure, which means you do sometimes think twice about whether you're going to exercise a right, even if you have that right. Hope this is fairly obvious, but landlords do have to, they're obliged to keep your property in good repair, which means the structure, gutters, pipes, water, gas, electricity, installations, and things like basins, sinks, baths, toilets, and appliances for heating and hot water. So all the normal things you would expect to have in working order. The landlord is legally obliged to do that, but of course he can only respond if you let them know. So do always let your landlord know at the first stage if anything is wrong with your home. I mentioned here that homes must be fit for human habitation, and that is a relatively new law, and it's important because it goes further than disrepair. So it would cover things that were just basically wrong because of the design of the building, like condensation, or also, crucially, if it's got things like dangerous cladding. You probably know, if you've been in the UK for a while, there was a horrendous fire in a tower block, and the tenants at that time, it was before this legislation changed, so they couldn't actually sue the landlord because the cladding wasn't in disrepair, it just wasn't fireproof, and with disastrous results. But fitness isn't actually a standard, so it's up to the court to decide on each occasion if you make a claim that your home is not fit. We've actually, one of the things we're campaigning on is to have a proper fitness standard, so we have a better idea of where we are with that. And you also have a right to the quiet enjoyment of your home. Now, if you're living in a city, of course, it's going to be noisy. You're not talking about living in silence necessarily, but it does mean that your landlord can't keep popping round being a nuisance. They have a right to come and visit from time to time just to make sure that everything is in order and you're treating the property reasonably well. But they shouldn't come for no reason. And also, if there's building works going on, then they should be controlled and not be working, say, late at night or very early in the mornings. I mentioned rent, challenging your rent when you first move into the property. More commonly would be the need to consider carefully when the landlord wants to put the rent up. It's possible that you and your landlord can negotiate a rent increase, and if you think that's reasonable and you can afford it, well, there's nothing to stop you agreeing that, and that's fine. But if the landlord just says, oh, I want to put your rent up from next week by £50 a week, and you think that that isn't reasonable, well, you can politely say, well, I'm really sorry, I'm not going to agree to that. And in that case, you can carry on paying your current rent. The only way that your landlord can enforce a rent increase is firstly, if there's something actually in your written tenancy agreement which says something like the rent is going to go up 5% every year, or it's going to go up at the rate of inflation, or some clause like that, which is actually fairly uncommon. So if you haven't got that kind of agreement in your contract, then the landlord wants to increase the rent lawfully and you haven't agreed, then he has to serve you a formal notice, which is called a landlord's notice proposing a new rent under an assured short hold tenancy. And he has to fill that in. And I've just squeezed the top of the notice in on the slide so that you can see what that looks like, what to expect. But I would always say back to the idea you haven't got security of tenure, so do seek advice if your landlord is proposing a rent and you want to challenge that. Just to quickly finish off that, if he serves that notice and you accept it or you don't do anything, then within the 4 weeks notice that he's given you, that does become your lawful rent, and then that is the rent that is due and that you have to pay. But if you continue to think he's asking for too much, again, you can refer that notice of increase to the property tribunal, and they will then decide whether it is a reasonable market rent or whether to reduce it. Again, there's a small risk because they might even think it's worth more, but so you need to do your homework before you challenge the rent, but don't disregard it either, because if you can't afford the rent, you're going to have to move anyway. Okay, a few things about your own duties as a tenant. Obviously, key is to keep to the terms of your tenancy. There are sometimes terms in a tenancy which are deemed to be unfair as a contractual term, in which case they're not enforceable. For example, if the landlord says you can't keep any pets, well, if it was just a blanket clause like that, that would probably be unfair. But if the landlord said you can only keep pets with express consent from the landlord, so I mean, if you wanted to proposing to keep an orangutan or something, then it would be reasonable for the landlord to say no. But if you want to keep a goldfish, well, one would assume they would agree to that. Obviously, key term is the rent, and it's very important that you do pay that on time if you want to keep the roof over your head. And if you do have any problems with paying the rent, if you've got a reasonable relationship with the landlord, do explain to them, get independent help. In fact, because of a lot of people lost income during COVID, most local authorities now have a government fund, which is intended to help prevent people becoming homeless because of rent arrears. So if you contact your local authority, you might find that they can actually give you a grant to cover your arrears so you can get back on track.
Jackie, sorry to interrupt. I think we're going to have to move on to Sam now.
Right.
We've got quite a few slides left, but
yeah, I mean, I just very quickly say, shared parts, keep them free, because they really are a fire risk in the event that you should have a fire. I think I can leave then the part 3 is about ending the tenancy, and there's a slide which just gives you some advice about what you want to do if you want to leave yourself, and then a lot of really important things to note if your landlord is seeking possession from you. Okay, sorry to overrun, but right.
That's okay.
Details.
Yeah, we can share the slides. You gave us permission to do that, and we'll definitely share with the participants. But hopefully there's given you guys a taster of what you should be looking for, and now you're curious enough to learn more. I certainly have. I didn't know that we had this right to challenge rent based on the local market rent. So I'm sure that Sam and Dave will also touch on that, based on like what can you do when now that you know you're right, what can you do with that? But let's move on to Sam now, who focuses a little bit on housing rights, especially for EU nationals, and what you can do if you're in need of housing support. Over to you, Sam.
Yeah, I'm just going to try and briefly cover. I mean, obviously the law is quite complicated on this because it's a mixture of immigration and housing law, and you'll all know already how complicated immigration stuff is. But I want to try and distill it down for EU nationals to the stuff that you know. And I'm assuming that most of you arrived here before 31st of December of, 2020. But before I do that, just what's happening with EEA nationals. Say you were entering the UK now for the first time, then you'd be treated as if you were any other national from any other part of the world, so Africa, Australia, wherever you've come from, and you'd be subject to immigration control and all the hostile environment that you've probably heard about, and your organisation probably campaigning on. And you require what's called leave, which is basically legal permission to be in the UK, and you apply to the the Home Office for that. So you need leave to enter the UK, and if you haven't got that, then you're an illegal entrant. And if your leave has if you came into the UK and your leave has expired, then you're what's called an overstayer, and that would actually be your position now if you were an EU national and you hadn't applied to the EU settlement scheme. Technically, you would probably be an overstayer. What I'm going to talk about is your right to qualify to join the local authority waiting list, to get help if you're homeless, or to claim universal credit or housing benefit if you've lost your job or had a reduction in income. The basic difference between universal credit and housing benefit now is that housing benefit's only for people age 66 or over. If you're making a new claim and you're under 66, then you'd claim universal credit, and that would include an amount for your rent. Now, in very broad terms, anyone from whatever part of the world you're from, you need leave, so permission from the Home Office, and you need that leave without a public funds condition or without a sponsorship agreement. Sponsorship agreement is where somebody signs an undertaking that they will support you if you're unable to. So you basically need that, and you also need to show that you're habitually resident. That just means that you've established residence here and you actually make your home here as well. Now, EU settled status and EU pre-settled status are both forms of leave without conditions. So nominally you are entitled, but it's a little bit more complicated if you've got pre-settled status, which I'll explain. So if you've got EU settled status, then you're entitled to homelessness assistance if you become homeless from the local authority. You're entitled to join the local authority waiting list and claim universal credit or housing benefit to help with your rent, provided that you're habitually resident. If you've got pre-settled status, then you're only entitled if at the time you make your application or you make a claim for universal credit, you have some other EEA right to reside. So those are your old free movement rights. So you need your pre-settled status plus one of your free movement rights in order to be entitled. And just at the top of the slide there, something that people don't often appreciate. And they think housing associations are like local authorities. Well, they are similar in lots of respects, but they don't count as public funds. So provided you're not going through the local authority to get on the housing association waiting list, some housing associations have open waiting lists, and you'd have the right to join that regardless of what your status was, whether you'd registered here or not. So this is about people who've got pre-settled status. So you remember I said that you need one of your old free movement rights, and you have to show that you're habitually resident. Well, if you're a worker, basically you're employed, or you're self-employed, or you've got retained worker status, then you're exempt from that test, and so you pass straight away. So anybody who's an EU's got pre-settled status and is in work should be okay, nice and easy. The problem is well, the two main problems are, one, if you're in part-time work, the Department for Work and Pensions will ask you how much you're earning, and quite often they go through this two-stage test. And if you're earning not enough to pay national insurance, which is currently £184 a week and will be £190 in April, then they may well say that you're not a worker, but you can challenge that because that's not what the actual law says. So, for example, if you've been here for a substantial period of time, you've been working, say, for 6 months, part-time, working probably at least 10 hours, probably a bit more a week, then regardless of whether you're earning enough, then if you've been working for 6 months, you should still be a worker. If you were working and you've lost your work, then you actually retain your worker status whilst you're registered unemployed. So the one bit of advice that I'd really stress tonight, and if you've got other EU colleagues who are in the same position, really stress on them the importance of making sure that you register your unemployment. That basically means going down to the job centre, and regardless of whether you're going to get benefit at all or not, register and do your signing on and be available for work, because that will then keep your worker status indefinitely whilst you're registered there, and then that will then go towards your 5 years and you getting your settled status. If you haven't worked in the UK for at least a year, and that year doesn't have to be continuous, it could have been, it's just a year in cumulative, then if you register as unemployed, you should still retain your worker status for at least 6 months. And then after that, if you're continuing to be registered, you have the right to reside as a job seeker for a further 91 days. That's just under 3 months. That wouldn't entitle you to benefits or housing, but it would at least retain your status. And if you're off sick, temporarily unable to work due to sickness, then you can also register that as well. And there's no time limit on that. So if you are in this position where you've only worked 6 months, if you have a period of sickness, register that, because that will keep you going for longer. So really, really important. Stress the need to your friends and colleagues about going to register, because you can't. The problem usually arises that, understandably, people who've been here and are used to working, I think, well, I'm not going to register because I'll get a job in another week or so, and then a week becomes 2 weeks, and then 2 weeks becomes a month. The problem is you can't go back and undo that. So if you have a gap that's longer than a month, you might end up wiping out all of your rights. So you don't want to do that. So really stress to people, nag them, go down to the job centre and register. Doesn't matter if you do get a job very soon, but please don't wait and hope. There are other EU rights to reside, which would also qualify you for housing and benefits. So if you were here as a student and you'd filled in your declaration that you'd got sickness insurance or you were self-sufficient, and there are various other rights to reside as well. So if you'd worked for a bit in the UK and then became completely incapable of work because you would, perhaps had an injury or something, then that would give you a permanent right to reside before the 5 years are up, and then you could use that to get your benefits. Other people, you can also get rights as a family member, whether you're so if you're the family member of somebody who's a European national, whether you're a European national or not yourself, basically you take the same right as that person. So if they're a worker, then you'll be treated in the same way as if you're a worker. And then certain people retain their family member rights. These are quite complicated, but I'll show you where you can get advice on these. So let's say you came here with an EU national and you used your family member rights and they died. You'd have, in most cases, retained family member rights. So you still have a right to reside, and you could use it provided you were a pre-settled status. And also for late registration, this is for people who didn't register. The Department for Work and Pensions published a circular. It's that one there, which is basically their official guidance, which says if you can make a late application, and if they accept your late application, they'll then treat you. So if they accept the late application and give you settled or pre-settled status, then you'll be back into, you'll normalise your position. And there's a link there to reasonable grounds for late application. So if you come across friends or colleagues who haven't registered, then certainly have a look at that. Not everybody will be accepted, but those with particularly children who haven't been registered, they might be able to get through that way. Okay, and this is where you can get more information on all of that, on your status, whether you've got family member rights or whatever. This site that Chartered Institute of Housing publishes, you can get the information there. It includes all the housing rights in England, Scotland and Wales. So there are separate pages for that. And the site's split into two halves as well. So there's kind of a what we call the new arrivals page, which is basically for you people, which simplifies things down a little bit. And then we produce the other half as well, which you can also get access to, which is for advisors. So if you've got a really complicated case and you need to look at case law and stuff, you can look at that as well. So that includes your details about your right to rent, your right to homelessness assistance, and your right to universal credit, and we update that regularly. You can see we've got a Brexit news page there as well, which is part of that site. So when you go into that site, you'll go on the landing page first, which will ask you which part of the UK you're seeking advice from, whether it's England and Wales or Scotland, and that service is free. Okay, so I think we're taking questions at the end, aren't we? So I'll leave.
Yeah, we'll do a collection of questions in the end.
Yeah.
Thank you, Sam. Really good to learn about the Housing Association open list. That's again something new to me. And just to say to the audience, if the mention of CSI is something new to you, go to our YouTube page, and the previous webinar was entirely about comprehensive sickness insurance, so you can find out more there. So Sam, if I ask you to stop sharing your screen, we're going to go to Dave next.
Okay.
Cool. Thank you. Yeah, so next on is Dave Aldrinkle. He's the national organizer of Aircon Union, and basically everything that you've just learned and more that you're about to learn, if you feel like you've been negatively impacted by housing and you feel like you want to campaign on this or protect your rights, he will tell you what to do. So over to you, and feel free to take 10 minutes, full 10 minutes.
Nice one. Thanks very much, Lara. Thanks to the previous speakers as well. Nice one. Yeah. So I'm Dave. I'm one of the national organisers for Aircon. Little bit of background about who we are and what we do. So we're founded in Bristol in 2014. We're a mass membership organisation, basically made up of low to middle income people organising for a fairer deal. So the idea is fairly simple but quite ambitious. The idea is to build like a national community organisation along the lines of a trade union or like a workplace union or a workplace syndicate, organising communities and fighting for a better quality of life. So from 2014 to now, we've gone from like just 5 people knocking on one estate in Bristol in a single neighbourhood to a national organisation with thousands of members, and we're influencing politics and decision making at the highest level. You know, taking on big banks, taking on rogue landlords, and taking on multinational companies. So in terms of what our aims are, basically we think that inequality, social problems, and housing problems included within that, it's all about power. We think the only way that we're ever going to see any meaningful action is if we can counter the power of money and establishment politics with the power of people taking collective action. Everyone's got a right to a place at the table. And what we're doing as Aircon, as a community union, as a people's organisation, is putting the community at the heart of the fight for economic and social justice. So every day, you know, we hear the issues that are facing our communities, like rising housing costs, like we've spoken about earlier, stagnant wages, brutal cuts that have completely starved public services in every city and town across the UK. Wealth's being transferred upwards, do you know what I mean? Like it's still happening. The only solution is for people to get organised and win it back. We're not outnumbered, we're just out organised. So, you know, we're nurses, we're shop workers, delivery drivers, carers, parents. We raise the young, support the elderly, and produce all the wealth. We power society, and at Aircon, we think we're entitled to our fair share, as I'm sure you do as well. So yeah, in a few years, we've gone from this small group to this massive organisation, and like our victories do add up to millions, but it's more than just pounds and pence. Like what we're doing as an organisation is by showing that by working together, you can actually rebuild democracy, rebuild communities, and that's what we're working to do. In terms of our tactics then, so what we do is we use something called direct action. So you might have heard about direct action. What it actually means, it's what we use to win. And it means the people who are affected by an issue take an action to force the person with the power to change it. So we're going directly to the person responsible, the person with the power, the person with the capacity. So we're not asking for handouts or good wishes from people in power. They're failing us, ultimately. The problems that we're facing as private renters or as low-paid workers, it's because people in power are failing us, and they are repeatedly failing us. And at Aircon, we're going to make them pay for it by giving us the resources and the power that we deserve. So you're probably wondering what this has got to do with the private rented sector. Part of our organising is something that we call member defence. So this is part of our organising alongside general citywide campaigns or national campaigns, part of our organising where we mobilise to defend the direct interests of our members. And this is it's usually around housing, usually private rented housing, but also social, also council as well. So there might be existing members, or they might, more often than not, they get in touch with us saying they have an issue with the housing situation. The problems that they face is like money, harassment, eviction, or disrepair. These are the 4 things that people are facing, and these are the things that we're fighting on every single day across the UK, across England and Wales. So how do we do it? So we focus on 3 things. It starts with members leading the fight, members leading the campaign. Members are regularly building campaign teams, and they use 3 things to build and to win. So firstly, they use strategy. So a strategy is a plan for getting from A to B, basically. You're rarely going to win without a strategy, and if you have one without a strategy, it was probably pointless because it's a fluke, and you won't win next time. As a membership, and as as working class people, like we're time poor and money poor. The 2 things we all wish we had a bit more of, time and money. We can only win if we strategize and pull what little resources we have and use them to fight back against landlords or against politicians or businesses. So we can use that strategy to maximize our advantages and their weaknesses, minimize our weaknesses and their advantages. So we're going to get a strategy. We're going to look at what demands we want to make of them. Do we want to stop the eviction? Do we want the repairs made? Do we want compensation? What have we got? What have we actually got to use? We've got members, we've got time, we've got this many leaflets, we've got a big banner, we've got a van. What actually have we got? Who are the people? Who's the target? Who is that one person who we can target and put pressure on to win? And then what we're going to do to them? What direct action are we going to take? So we work that out in our strategy, and then we move on to direct action. So we win by taking direct action. People might have heard about direct action before, and I've got some pictures of what direct action actually looks like. It's something that's talked a lot about. But like this country's got an amazing history of taking direct action. I mean, I'm in Leeds now, and over 100 years ago, there was the Burley rent strike, where working class community in Leeds refused to pay the rent in protest against it being raised. Hey, it's a great tradition in this country, and I think we do stand in that. We do stand in that. So we're not going to fix the problem ourselves. Like, we're not going to go around and do the repairs. We're not going to pull people and go fix your bath or fix your boiler. We're going to get the landlord to do it because they're the person in power, and we're not going to let them off the hook. Through taking direct action, we're taking power away from them and keeping it for ourselves, you know, giving it to people who need it, low to moderate income people, giving power to our organisation. So we have strategy, we have direct action. And the next thing that we use is, and the sort of tool that we focus on is around developing leaders. And I think that's what separates us. Like, it's the biggest focus in how we fight bad housing conditions. And in my opinion, what separates our approach from anyone else is our focus on developing leaders. So let's say, Larry, you're a tenant and you come to your local Aircon branch. Say you want help with something. We've got a rule, like, never do something for someone they can do for themselves. Like, the tenant is going to take on as much work as possible, and they're going to take responsibility to solve their own situation. And this is like a brilliant thing because ultimately there's an essential dignity in everyone. You know, people aren't weak, people are made of glass. We ask people to fight to solve their own situations. It develops them, gives them confidence, skills, knowledge, and then next time when their next door neighbour's getting evicted, they can lead the fight with them. So that's what separates us out from other organisations. We're not going to do anything for people. We're going to, I mean, I was a member, then I became a staff member. People come to Aircon having never demanded anything in their life. And then before you know it, they're leading some direct action, confrontation, negotiation, leading the fight and, you know, rebuilding the community, which is pretty amazing. And it's part of the reason why I love this union so much. So, you know, why do we do it? Like, I'll show some actions in just a bit, but why do we do it? Like, getting down to the bones of it, like, there's two types of power in the UK, and you know, two types of power anywhere. There's organised money and organised people. We've got not very much of one and a lot of the other. So through member defence, fighting for better conditions, we're building an organisation that can fight for anything that the community needs. So yeah, that's why it's so important to fight back, consistently fighting back. And I'll just show you quickly what some direct action actually looks like, if I can share my screen very quickly. Can people see that all right?
Yeah.
Nice, sound. So this is some direct action that we took in Leeds. There was a family of 7 getting illegally evicted by their landlord. They refused to pay their rent because the house had rats, cockroaches, there was no boiler. Pretty appalling. So the landlord's response to that was very helpfully threatening to evict them. So what the Aircon members did in the area, went round to the landlord's house, got some strategy together, confronted the landlord and made him agree to not evict them. And now they're in permanent housing now. So they've gone from being made homeless illegally. The council weren't going to do anything. Councils are often stripped, they've got no resources, but the community have got resources because we've got each other. So they've got permanent housing now. You've got 5 kids who've got a home and they're not on the streets or in temporary accommodation. Another example is something quite recently. Member in Bristol, called Fadimo. She's living in the house with her kids. It's absolutely uninhabitable. And this is some action that we took just the other day. So this is what direct action looks like. It's people standing together, using strength in numbers to fight back and to win. And the good thing about Aircon, that in my opinion separates us again, is that we do actually win quite a lot of stuff, which I think is quite a rare thing to be involved with. You know, we've stopped countless evictions. We've won millions in repairs and compensation. We've won like countless improvements, you know, from stopping evictions from families, you know, of stopping kids getting evicted, right up to getting like flammable cladding removed from tower blocks, and repairs done in high rises. Like, there's nothing that can't be done. And something that we've really learned through doing this is that, you know, the tenants are more powerful than the situation seems. And through organising, people can do things that they never thought they would do. The counterpoint to that is that with landlords, there's rarely a depth that they won't go to. That's all the more reason to join a union, join a community union, and join Aircon. We're in over 20 different cities and towns: Leeds, Liverpool, Newcastle, Cardiff, Coventry, York, London, Sheffield, Cambridge, like all over the place. Wherever you are, become a member of Aircon. likelihood is we've got a very big, very active branch where you are, and even if we don't, get in touch. We're going to start one. We're growing all the time, month by month, and taking on bigger and bigger stuff. And yeah, you can be a part of the next win, because the wins are coming all the time. My call to action for everyone here is to join Aircon today. So we're a democratic membership organisation, and to be a part of it, it's an hour's wage a month. So people pay what they can, people pay what they can afford. They also give what time they can afford. If you want to push back on your landlord, or if you want to see a better change in your community, not even around housing, Aircon's the only place to do it. Thank you very much. That's me.
Thank you very much. I think just to remind everyone, like May last year in Glasgow, a community got together to stop the deportation of 2 refugees. So things like that do have an effect and work. And again, I think as migrants in the UK, it takes a long time for you to feel confident to one, know what your rights are, and then to speak up for yourself. So it really does matter when you're able to do that with others who are on your side. So thank you very much, Dave. And now we've got some 15 to 20 minutes for questions. Thank you very much, Sam. We've been starting to answer some. I'll just read out others, and then some might be more appropriate for Jackie, but if anyone has the answer, feel free to jump in. Jackie, there's one here that says, my landlord asked me if I have a job. I'm currently unemployed. I don't like lying, but out of fear of being kicked out where I live now, or basically, what should they say? Are they legally required to tell the landlord if they have a job or not?
Yes, that is a difficult one. I mean, a lot of landlords do, excuse me, do actually ask for references, which often include from an employer. It isn't a good idea to lie to your landlord. It's not going to be too difficult to find out anyway. And in fact, one of the grounds for getting possession, evicting a tenant, is if they have given a substantial false statement. But presumably you wouldn't be taking the property unless you were reasonably confident that you could afford the rent. So the thing is really to explain to the landlord how it is that you can pay, what your income is, how reliable it is. If it's possible, also to offer a guarantor. I don't know if you've got any parents or relatives who might be willing to stand as a guarantor to pay the rent if in the unlikely event that you didn't pay it. That is usually, landlords will usually find that a satisfactory reason. But yes, it's a difficult one, but you know, if you're not working, you're not working, and there's nothing you can do about that.
Yeah, unfortunately. And I know that some people try to pay like certain amounts of money in advance to satisfy the landlord.
Yes, that's another way you can do it.
Okay.
Yeah, and of course, if you're out of work, then you can you may be able to claim those claim universal credit to help pay your rent or housing benefit if you're over 66. There's nothing to stop you doing that. So the landlord can't block your right to do that. So that might help you pay the rent in the meantime, whilst you're in between work.
Got it. Thank you. And then we've got a question from Flo. Do these rights I think mainly Jackie talked about ASTs, do they apply if you're renting from a housing association as well, or just from private sector?
Most of those rights do. So the main difference with a housing association is you normally wouldn't pay a deposit. So, but because you're not paying one, that's not a problem. But the rights to repair, fitness for habitation, all of those are the same for housing association tenants as they are for private tenants. And the rights to security, you know, not to be evicted are the same. And in many cases, you'll actually have better security if you haven't got an assured short hold. You'll have your landlord will only be able to evict you on certain grounds, much more similar to a council letting, where normally the landlord has to show that it's reasonable to evict you. That's only a very broad summary, but that's
okay. Great, thank you. And one interesting here from Christina about like blanket bans on no pets when advertised. Is there anything that someone trying to rent can do if they have a pet, or is there like a campaign for legal changes on that? Is there any update on it?
Well, as I said, if it's an unfair clause in an agreement, it's unenforceable, and the same really would apply if it's advertised as no pets, unless there's a really good reason why the landlord couldn't have any form of pet. So I think I would be inclined, not necessarily I just say ignore it. If you apply for the property and you intend to take a pet that you know is not going to be creating a big problem in terms of damaging the property or anything, then I would just apply for the tenancy in the normal way.
Cool, thank you. I think one for Sam, but might be, I don't know if you can answer. Do the rights that you talked about, EU citizens, apply to those on a family permit through the Surinder Singh route?
The Surinder Singh rights are covered on the website link, the housing rights website that I linked. So to get the Surinder Singh rights come through your you being accompanying a British citizen. So if you click on the tab for British citizens on that site, it will explain those rights there. But generally, yes, if you've already established your Surinder Singh rights, then you will be okay. But those rights, like the settlement scheme, you need to have applied by a certain date, and it's a bit more complicated because it depends on when the British person you accompanied, when they arrived back in the UK and when you come to visit them. So I think there are still existing rights up until the 29th of March. We've got that covered on the page. So you know that generally for EU nationals, the settlement scheme closed on the 30th of June of last year. It's still open for some people with Surinder Singh rights up until the 29th of March, but that is explained on the page. It's very complicated, so I don't want to kind of go and have a look, and you can get more details there.
Well, thank you. So let's go to a live question from Shukri now.
Hi there. Hi. Good evening, guys. Thank you for giving your presentation. I had a question. I've been looking for housing for my aunt. She is in British, and a lot of the housing associations have these clauses saying you can't apply with us unless you have indefinite leave to remain or be a British citizen. And I'm like, that sounds, I don't know, not quite fair. Is this like a countrywide thing or just a local area?
No, they can't actually do that. So I would challenge that if I was you. A lot of housing associations get confused about the rules, and it's different between. So I said you can apply to a housing association if they've got an open list. So some housing associations give nomination rights to the local authority. So you can only apply via the local authority. You then have to show that you've got one of the qualifying immigration rights. So if you're an EU national, for example, that would mean you having settled status or pre-settled status. But it's only if it's via the local authority those rules apply. If it isn't, and it can be a bit more complicated because some housing associations have both, so they have some nominations and they have some via an open waiting list. But you should challenge that, because they have a duty not to discriminate, and just putting down a nationality status is quite obviously discrimination. So there is information on that on the housing rights website thing that I gave you as well. So if you click on the link about information about housing associations, you can look at it there. But I have to say that a lot of housing associations don't understand the rules around immigration, and they just kind of play it safe, or try to play it safe, but they shouldn't be doing that. They can't just blanket refuse you on immigration status. So you can challenge them on the grounds of discrimination on that. But it will, if you are going via the local authority, then you will need some sort of qualifying right, be it either as an EU national with settled status, or some other form of leave which doesn't have a public funds condition. That's a very broad summary. It will depend on the kind of right that that person has, but there are tabs on the website for different types of immigration status that you can have a look at. So hopefully that will help you there.
Thank you. There's a question from Leo in the chat. I think if I don't know if anyone can read it, because it's a lot of information, but I'm in the UK since 2013. Since 2020, my disabled father has been living with me. I have powers of attorney over his health. Although I'm his real carer, I can't be his official carer, and he was denied not eligible for AA. I don't know what AA is. Oh, okay, cool. Because of that, I can't add him to the council property waiting list, as their requirement is that I have to be his official carer, and he's not receiving AA. Basically, how can I challenge this decision?
Yeah, it's quite difficult because so local authorities have certain national rules that they have to follow about immigration status. But on top of that, they can then set their own criteria, but those criteria must be reasonable. So there might be ways that you can challenge that decision. So you have to apply first and then challenge it later. I don't know what grounds he was refused attendance allowance on. I'm assuming that he didn't pass the disability tests, but it's always worth trying again. So I'm assuming it wasn't on residency grounds. So immigration status, the rules are slightly different for attendance allowance. They're not strict. But you can challenge that, and a lot of people who apply for attendance allowance, which is basically like a personal independence payment for people who are over 65. A lot of people who appeal, who get a nil decision, appeal it, and there's a two-stage appeal process, and it's more than 50% of people who appeal are successful. So I would say stick in another claim there first, and then go and get somebody to advise you, be it through, you know, whatever kind of advice. So normally on benefits, Citizens Advice are very good. They quite often have specialist benefits advisors who will be able to take you through that. But yeah, register another claim first. The local authority waiting list application might be a little bit more complicated because it will depend on what the local rules are and whether those are reasonable at all or not.
Thank you. Dave, I think wondering if you can answer the question on the chat about like discrimination towards EU citizens, or if you ever worked on like just general discrimination of based on anything, and how Aircon has tried to deal with that.
Yeah, there are discrimination, particularly in the private rented sector. You know, where people from like alien employment, and also something we've had a big campaign around is like discrimination, refusing access to people who are on benefits. So like this is something that you do see quite a lot, and just because something's illegal or just because the council doesn't allow something doesn't mean it doesn't happen. And like, in fact, it can happen quite a lot. I won't be able to speak to any specific laws, but this is the kind of thing that you see absolutely everywhere. And I think like you are going to see much more often as like, you know, wages keep going down and as cost of living increases. As ever, sadly, my solution is always like we need to fight against stuff. We have successfully run like several anti-discrimination campaigns, particularly around benefits, and that was where we targeted 3 international banks and got them to refuse payments to anyone who actually was discriminating against, which was really effective. But like, sadly, I'm not always convinced that like the current systems are meant to not allow discrimination, but sadly we know it happens. So like, that's what, when we talk about an Aircon, like the people in power have failed us, they're the kind of things that we're talking about. But yeah, we have successfully won campaigns on that. And like, if it is something you think that you see happen quite a lot, like join up and get in touch, because that's something that would be great to run a campaign around.
Yeah, and just going back to the housing association question, it's just occurred to me. So if you were applying for a housing association you wrongly turned down, you do have a right to go to the independent housing ombudsman as well through a housing association. So you could challenge through that route. It might not get you the tenancy that you wanted, because that will take some time to go through, but you might at least get some compensation for that, and that would help also when you come to apply again, and probably help others as well. If you're challenging a policy that's clearly wrong, but you have to go through the formal complaints route first. So apply, get turned down, complain, if necessary do a second complaint if you have to do a second complaint through their complaints procedure, and then you can apply to the housing ombudsman, which is a statutory scheme, and they will look at it. And if you have been turned down on wrong grounds for a housing association property, they will issue a decision, which is it's not strictly binding, but it does have quite a powerful effect on housing associations. So I go down that route.
Cool. So like, let's go to one last question. Well, one quick question for Dave, which I think you can answer on the Q&A there, but is there one in Merseyside? But just generally, there's one there about general advice about taking my landlord to court. Maybe each of you, because we're nearing the end of the webinar, can kind of maybe close on this. Is it better to go straight to a lawyer, or is it better to try to do like a negotiation with your landlord first, or getting involved with Aircon? Maybe, okay, starting with Jackie.
Yes, I mean, I think in some respects you can do both. I mean, we work very closely with the London Renters Union and Aircon and others, because really we campaign as well to improve policy, but it's very difficult for a member of our legal team to be in court defending somebody one day and then on the picket line the next to stop them being evicted. So it's great that we have the Renters Union to be taking that direct action. I think it's partly comes down to the time that you have and whether you, I mean, court action takes time. I mean, I would suggest that you probably should always start by getting legal advice, so at least you know what your legal position is. But there are occasions where the Renters Union, for example, have stopped a possession where legally the landlord had a right to possession, where he's actually gone to court and got a possession order, but nevertheless the Renters Union has still prevented that person physically being evicted. So yes, there's nothing that the court bailiffs dislike more than arriving and finding a picket line outside of people with placards and shouting, making a lot of noise. So yeah, I mean, they're both really important. You should know what your legal rights are, know what your options are to be represented if necessary, and or quite often, even if you're not getting anywhere negotiating with a landlord, a letter from a legal firm like ourselves or private practice will bring the landlord to heel, and they'll realise that they've got to take negotiations seriously. And we can quite often, I mean, we've had a number of occasions recently where we've managed to get landlords to write off quite significant debts because we've been able to point out the conditions in the property mean that the client has got a counterclaim, but they don't actually have to use it because we can settle. So you need both, really.
Mm-hmm. Cool, thank you. And
Yeah.
same question. Yeah, go on.
Yeah, I was just going to say, generally, if you're going to court, then you need evidence of some kind. So, you know, kind of always start with your landlord and put them on notice. So, you know, kind of send them a letter and say what the problem is. And you don't have to be pushy at that stage, but it's important that they're aware of what the problem is, so they've had chance to address it. And if you've given them the opportunity and they've then declined, then the court's going to look more favourably on it. So send something and make sure that you've got some evidence. You know, either take a copy before you send it, or you don't have to send it registered post, but just take a note of when you sent it. So always start with that. So for example, with the fitness for habitation stuff, there is actually a defence there that the landlord didn't know. So you can't just kind of trick them into getting compensation. You have to show that your case is reasonable. So we'll start with just letting them know, and that can be verbal, but obviously it's then more difficult to prove that at a later stage. So a letter's always good. And you don't have to kind of up the ante to start with, but the mere fact that you've written the letter is helpful.
Cool, thank you. And final words from Dave and his cat.
Yeah, there was a question earlier about having cats in a no pets property. I've currently got 2 in a no pets property, so I hope my landlord's not watching this tonight. Yeah, I'll say the first question was like, is there a group in Merseyside? There is the mighty Aircon Liverpool, who are one of my branches. So you can definitely join, definitely get involved. They've got a very exciting campaign at the minute to get publicly run buses in the region. Not housing, but still very important. Sam, let me just remind myself of the exact question. So yeah, taking the landlords to court. Well, Sam said like, there's not a reason to up the ante straight away. But I agree with Jackie, like, we need both. Like, ultimately, we want legislation that's going to work for working class people, low to moderate income people. And the way we view it, like, the courts weren't built and the laws weren't written by people like us, and they weren't written and designed to work for people like us. They were written and designed by landlords, by people with property, by people who own stuff to work for them. Do you know what I mean? So, like, you know, where money poor and time poor are the 2 things you need to go through a court process. Glad to see Kathleen was allowed 1 cat. That's what I like to see. Yeah, you know, if we can go through the court process and win, but like, we haven't got the money to do it, we haven't got the time to do it, we don't know the lawyers. Like, the landlords have got more money and more time than we do. But what we do have is each other, and like strength in numbers, and yeah, having a community organisation is going to work for you. And yeah, you know, you don't have to up the ante straight away, but you know, there's nothing wrong with doing that, and there's nothing wrong with demanding rather than asking. Like, why have we always got to go cap in hand to the landlord? Why can't they be afraid of asking us for things? Because that's how it should be. You know, they're not providing anything to us. We're providing them by paying off their mortgage, by paying more than 1/3 of our wages to go straight into their bank account when we're the ones grafting for it. So yeah, like, don't take anything from your landlord. Like, stand up to him. Although I do, yeah, we need both. We want to change the laws and make a country that works for us.
Thank you very much. Very inspirational. I think we all learned a lot. I did, and very inspired to go look for my local Aircon branch as well. And I hope that everyone has learned a little bit. We will follow up with the slides that have been presented today and some other information about general EU settlement scheme rights and the CSI comprehensive sickness insurance issue that has been touched on as well. Now you know about these groups and this organization, so if you have specific questions, feel free to ask us and we'll try to find the information or reach out to them directly. There's plenty of links on the chat, which will be shared on the follow-up email as well. I'd like to say a big thank you to Jackie, Dave and Sam for taking time to be here with us today and sharing their knowledge with us. So thank you so much. And yeah, hope you have a good evening and rest of the week as well.
Thank you.
Bye.
Bye.
Bye, folks.